is a unique jurisdiction vested exclusively at the moment in the Sindh High Court. Perhaps the Islamabad High Court enjoyed a similar jurisdiction at some point in time, but I think that experiment was jettisoned after a brief trial. Perhaps Justice Babar Sattar will be able to share the reasons for that in due course. But this original jurisdiction of the Sindh High Court dates back to the Sindh Courts Act of 1926, and it now exists by virtue of the Sindh Civil Courts Ordinance of 1962. And under the relevant section of that ordinance, any civil suits and proceedings over a particular pecuniary threshold originate in the High Court as opposed to the court of the district judge, which is the system otherwise prevalent all across the length and breadth of the country. As far as the way in which such cases are to be dealt with at the level of the High Court, the Chief Court rules already provide for a classification of what constitutes a commercial cause, and those commercial causes are meant to be accorded priority. But in practical effect, the way in which the jurisdiction is designed, and I had prepared certain slides. Perhaps if the first slide can be put up showing the wording of the section, which is section 7 of the Sindh Civil Courts Ordinance, that will give you some idea of the structure. That basically does not classify any subject matter. It simply says that any civil suits or proceedings at present valued at over 65 million rupees will originate in the High Court. Now, as and when the Civil Courts Ordinance was promulgated in 1962, this value was perhaps initially set at a much lower threshold of 25,000 rupees. It has been enhanced from time to time, from 5 to 5 lakhs, then to 30 lakhs to 1.5 crore. But what we have seen, and now if we can have the slide showing the relevant data, the figures show that as and when the jurisdiction has been enhanced, the level of pendency still continues to rise unabated.